Hello and welcome to another episode of my Q&A Thursday. Our question for today is from Lynn. She asks, I got married January 2015 last year. I already applied to sponsor my husband to come to Canada as a permanent resident. He received a letter from the Canadian Embassy last week. It said that my husband is excluded as a member of the family class as he was not examined before I came to Canada as a permanent resident. The letter said that my husband declared in his sponsored person questionnaire that we lived together in Dubai. That was before I came to Canada. But when I applied for my PR, I didn't declare him as my common law partner. We really didn't live together in Dubai because it's not allowed there. Can he still come to Canada? Can I still hire a consultant to help us with our application at this point? Lynn, I'm sad to note that your oversight may cause your husband to be considered as an excluded family member as per Immigration and Refugee Protection regulations. The procedural fairness letter you got means that you've been given a chance to explain the conflicted information you've provided. So there's hope that your spousal sponsorship application could still get approved. But it will take a lot of effort on your part to explain the inconsistencies of information provided in his current application under your spousal sponsorship and in your previous application for permanent residency. Here are the 6 steps you can take to rectify this issue. Retrieve your file copy of Form IMM 5669, that's the Schedule A background declaration form that you submitted for your PR application. Review your husband's copy of his Form IMM 5669 that you submitted with your sponsorship application. Compare the dates and addresses in your personal histories. Is there a common address in both forms that proves you lived together for 1 year or more? If your answer to number 3 is no, let out a sigh of relief. Get statutory declarations or affidavits from people you lived with during the cohabitation period being questioned by the visa officer. Ask them to state their knowledge of the fact that you really didn't live together. Look for as much proof as you can to put you as holding residence in different places during those periods questioned. Examples of these are postmarked documents, bank statements, IDs, rental agreements, etc. Compose a very detailed letter to clarify what your husband meant when he said that you lived together in his application form. Now, you might wonder, what if your answer to number 3 is yes? Unfortunately, that information will support the visa officer's speculation, and it will also support what your husband has claimed in his application form. In that case, you'll have to seek the help of an immigration expert. My dear, I can't emphasize enough the importance of providing consistent information. You'll say it's an honest mistake, and yes, I believe you. I've heard of the do's and don'ts in places like Dubai. So I know living together there would be extremely difficult. I can also understand that you were trying to impress upon the visa officer that your relationship is serious and committed. That's why you exaggerated on the fact that you lived together in Dubai. The sad thing is that honest mistake could cost your husband his PR visa. So Lynn, to answer your first question, there is hope that your husband can still come to Canada. And to answer your second question, absolutely, you can still add a counsel to your file. Actually, it would be a very smart move on your part. I'm including below my contact information as well as contact information of other RCICs that I can recommend to you. To those of you who are just putting together your application package, keep this in mind. Be consistent. Cross-reference all the information you provide in your forms with your documents. If you're not thorough, what you thought was a simple spousal sponsorship application could suddenly become very complicated. And if your case has become complicated, please seek expert help. I'm not against do-it-yourselfers. Retaining a reputable, regulated Canadian immigration consultant for your immigration application could cost a lot. So, if you're diligent and resourceful, by all means, do it yourself. What puzzles me though are applicants who encounter difficulties or complications with their application and still refuse to seek the assistance of a regulated consultant. The cost of retaining counsel is way lesser than the cost of a refused application. Now, let me ask you this. How much does losing your chance for permanent residence cost? The benefits you gain if your application is successful more than offsets the cost of having an expert assist you. Have you also experienced a complication with your spousal sponsorship? Care to share? Write a comment below and let's have a meaningful conversation that could help other couples going through some bumps in their application. Don't forget, help me spread this information. Please share this in your Facebook and Twitter. Thank you for watching my Q&A Thursday. See you next time.